Swayam Prabha. Digital India. Educated India.
Hello everyone, I am Dr. Kavita Solanki, Professor of Law at University School of Law and Legal Studies, Guru Govind Singh, Indraprastha University, Delhi, Dwarka. Today we will talk about Labour and Industrial Law 1, where we would be talking about lecture number 7, which is on Minimum Wages Act 1948. When we talk about the history of the Minimum Wages Act 1948, into which name of KGR Chaudhary is very important, because in 1920, KGR Chaudhary recommended setting up boards for the determining minimum wages for each industry, and in 1928, major factor was the ILO Convention number 26 on minimum wages fixing machinery. In 1928, International Labour Conference implemented system to fix wages for different trades. However, the practice was not put into legislation in India. In 1943, Standing Up Labour Committee or Labour Investigative Committee was appointed on their recommendation of the Indian Labour Conference. In 1943, to look into the condition of the labour in terms of their wages, housing, social conditions and employment. In 1945, the first bill on minimum wages was drafted in International Labour Conference. In 1946, a bill on minimum wages was introduced in Central Legislative Assembly on the recommendations of the 8th Standing Labour Committee. This 8th Committee of the Standing Labour in 1946, they also recommended that there is a need to have the separate legislation that specified working hours, minimum wages and paid wages, paid holidays of the unorganized sector to be enacted. In 1947, after the post-independence, representative of the labour, employers, government organized conference, they defined a minimum wages to be such they should not only provide for the bare subsistence level, but should also be enough for the education, medical requirements and other amenities, and should sustain efficiency. At last, in 1948, the Minimum Wages Act was eventually passed and was effective from 15th March. Under the Act, a tripartite committee that is on a fair wage was appointed, and that set the definitions and the guidelines for formulating a wage structure in India. The Committee of Fair Wage, they gave the definition of the minimum wage. They gave the definition and explained the minimum wages must be provided not for merely bare subsistence level of life, but also for the preservation of the efficiency of the workers by providing for some measures of education, medical requirements and amenities. Recommendations of this committee have now set the foundation of wage fixation. The Minimum Wages Act 1948 was enacted to give effect to the recommendations of the International Labour Conference in 1928, and it is a pioneering measure in the area of social justice. When we talk about the object of the Minimum Wages Act, the primary object of the Minimum Wage Act is prevention of the sweating or the payment of the unduly low wages to the unorganized sector. Welfare of the labourers, set the minimum limit of the wages, the philosophy of the Minimum Wages Act and its significance in the context of the conditions in India has been explained by the Supreme Court in Uniche versus State of Kerala in 1962. Because when we talk about the wages cannot be fixed in vacuum. While fixing wages, it is necessary to take note of of so many factors from real life of an employee as reasonably possible, it is obvious that some principles have to be evolved from the conditions and the circumstances of the actual life. Wages, by their very nature, are of the primary concern for both the employers and the employees. The employers always think of how to decrease the production cost, and while the employees see the wages in terms of their preoccupations, better housing, schoolings, food, etc. The Constitution of India enjoins upon the state to endeavour to secure condition of work, ensuring a decent standard of life, full enjoyment of leisure and social and the cultural opportunities. When we are talking about, that is the broadly the wage structure, this wage structure is divided into 3 parts. When we talk about the wage structure, it is like a ladder. When we talk about this, that is like it's like a ladder. So when we talk about, that is at the bottom level, that is the minimum wages. When we talk about in between, it is the fair wages, and when we talk about the top is, that is the living wages. So when we are talking about the minimum wages, so it is the bottom line. So this is the duty of the employer, is they should not deduct these kind of the wages. So because that is the wages, they are not so handsome wages, rather they are for the bare subsistence of the life, and this is the poverty line, we can say. And above this minimum wages is, as we draw now, that is the fair wages. It means that they are better than the living wages, because into the living they are better than the minimum wages, because the living wages is, that is the aim of the Constitution, and it has been mentioned into the directive principle of state policy, where this is the duty, and the state will try to achieve the living wages for their workers. So into the certain principles on which the wages are fixed have been stated by the Supreme Court in Kamini Metals and Alloys and their workmen. So when we talk about broadly, the first principle is that there is a minimum wage which in any event must be paid, irrespective of the extent of profits, the financial condition of the establishment, or the availability of the workmen on lower wages. Sometimes the employees, they are ready to do work on lesser than the minimum wages, but it would be considered to be the beggar, and for which into the Constitution we are having the Article 23. If someone is taking the work which is lesser than the minimum wages, the person can be prosecuted for it. The minimum wage is independent of the kind of the industry and applies to like big or the small. It sets the lowest limit below which the wages cannot be allowed to sink in all the humanity. The second principle is that wages must be fair, that is to say sufficiently high to provide a standard family with food, shelter, clothing, medical care and education of the children, appropriate for the workman, but not at the rate exceeding his wage earning capacity in the class of the establishment to which he belongs. So fair wage is, when we talk about, is related to the earning capacity and the workload. So that is, the fair wage is, it has been realized that it is not, but the fair wage is not living wage, by which it is meant that wage which is sufficient to provide not only the essential above mentioned, but a fair measure of the frugal comfort with an ability to provide for the old age and the evil days. Fair wage lies between minimum wage which has been paid in any event and the living wage which is the goal, as we mentioned now. So when we talk about minimum wage, this expression minimum wage is not presumably defined into the act, because it is not possible to lay down a uniform minimum wages for all the industry throughout the country on account of different and varying conditions for prevailing from industry to industry and from one part of the industry to the another, and it was held in Hydro Engineers Private Limited versus the workmen. So we are having the norms for the fixing of the minimum wages. The tripartite committee of the Indian Labour Conference in 1957, they accepted the following 5 norms for the fixation of the minimum wages. So when we are talking about the minimum wages, in calculating the minimum wage, the standard working class family should be taken to consist of 3 consumption units for one earner. The earning of the workmen, children and the adolescents should be disregarded because it is very important. So 5 norms has been taken into the consideration for fixing the wages because it is not possible to have the uniform definition throughout the country. So here the normally when we talk about the wages is a one earner that is consisting of the family unit. It means including this earner, he is having the 4 members. That is including this person, total is 4 members. So when we would be deciding the wages is, the wages has to be decided in that way. This person can maintain his family, so he can provide the food to the children, to the wife, or to the 3 consumption unit into the family. But if into the family of this workman, if the child or adolescent or other member, they are doing the work, their wages should not to be taken into the account. So their wages has to be excluded when we are talking about the minimum wages. Minimum food requirements should be calculated on the basis of net intake of calories as recommended by Dr. Arcreod for an average Indian adult of moderate activity, because it is very important that the calories intake has to be taken into the account and they must have to give the wages accordingly. So normally when we talk about how many calories is required for a male or for the female and what has to be into that calories, the grains, the wheat, rice or cereals, so they would be deciding what to be included into those wages. So calorie component has to be taken into the account for deciding the minimum wages. After that, clothing requirements should be estimated as per capita consumption of 18 yards per annum, which would give for the average worker family of 4 a total of 72 yards. So it is expected that clothing, because normally when we talk about, we expect that is clothing has to be at least can be adjusted from the wages. So when we are talking about clothing requirement, it means that is a 4 members, a per person per capita, that is a 18 yards per annum is equal to that is 18 into 4 is 72 yards per family. Clothing requirement has to be maintained from the minimum wages. In respect of housing, the rent corresponding to the minimum area provided for under the government industrial housing scheme should be taken into the consideration in fixing the minimum wage. Fuel, lighting and the other miscellaneous items of expenditure should constitute total of the minimum wage. So when we are talking about, so for these kind of the components, say fuel, lights and the other items, so 20% of the wages has to be counted, minimum wages has to be counted for that. So the wages has to be given accordingly, the norms which has been given. Sometime the question comes for the constitutional validity of the minimum wages, because the employer says, I am not in a position to carry on the burden or otherwise I am into the loss. So it should not to be expected from me to give the minimum wages to each and everyone. And employer is saying, this is my constitutional right to carry on any kind of the trade or the business. So this is my fundamental right. So unreasonable restriction should not to be imposed upon me. But for this, because it has been clearly mentioned that it is not a violative of your Article 19 Clause 1, Clause G, because that is Article 19 Clause 1, Clause G is into the Constitution to practice any profession or carry on any occupation, trade or the business. So, but if the person is not in a position to maintain the industry, not in a position to give the minimum wages, which is the bare subsistence level of the worker, then he is not having any right to run any kind of the industry. So for this, the Constitution, through the so many cases, it has been held by the court, there is no violation of any right. So this is, if we are talking about constitutional validity of the minimum wages, this is absolutely valid, and reasonable restriction can be imposed upon the employer if they are not in a position to give the minimum wages for their workers. So the first challenge to the constitutional validity of the Minimum Wages Act 1948 arose in a case of Bijoy Cotton Mills Limited versus State of Ajmer. And here the Supreme Court ruled that acts which are given here, they are not unreasonable, and any person is allowed under Article 19 of the Constitution. The court highlighted that these provisions were enacted for the public interest in line with the directive principles of state policy outlined in Article 43 of the Constitution. Although these provisions might pose challenges for the employers in conducting or initiating businesses, they were established to safeguard the broader public interest. As such, the Act could not be considered unreasonable or invalidated on these grounds. Minimum Wages Act is not violative of Article 14 of the Constitution, which states equality before the law. In the case of N.M. Wadia Charitable Hospital versus State of Maharashtra, the Bombay High Court ruled that setting distinct minimum wage rates for the various locality is in accordance with the Constitution and the nation's labor law. As such, establishing different minimum wage rates for different regions is not discriminatory and does not violate the principle of the Constitution. So, this is not possible, because when we are talking about uniformity into the minimum wages, because in India we are having the different the geographies like this. So, this is not possible to have the uniform rate of the wages when we are talking about, because when we would be talking about how to decide the minimum wages, what kind of the component has to be taken into the consideration is, so if we are talking about the minimum wages for the Delhi or any other metro city, of course the wages would be high, because there is a cost of living index is very high. So, DA has to be given accordingly. So, any of the employee they can meet out the cost of living because they are residing into such a metropolitan cities. But if someone is residing into the other states where the cost of living is not so high, so the wages would be low. So, it is not possible to maintain the uniformity into the definition of the minimum wages. Hence, the Minimum Wages Act is in Constitution valid with respect to Article 14. Minimum Wages Act is not violative of Article 23, which prohibits on the forced labor, because when we are talking about the forced labor is because beggars cannot be choosers. These employees, they are not having any other option. That's why because of their situation, they had been compelled because of their circumstances. That's why they have become agreed to work on lower than the minimum wages. That's why the Constitution safeguard is here, and the title has been given, that is that's why we are saying this is the beggar or the forced labor. So, if someone is not giving the minimum wages to their workers, that the person can be prosecuted for this, because this is the criminal offence. The importance of providing labourers with wages that cover not only basic survival but also uphold health and the dignity is a matter that's difficult to challenge. This aligns with the directive principle of state policy found in Article 43 of the Constitution. Employers could not raise the concern if they are required to pay the minimum wages to their labourers, even if these labourers, due to their financial constraints and vulnerability, might agree to work for the lower wages. So, this perspective was upheld in the case of the Bijoy Cotton Mills versus State of Ajmer. When we are talking about this act is called the Minimum Wages Act 1948, and it extends to the whole of India. In section 2, we are having the important definitions. So, when we talk about these definitions, we are using the term adolescent here. Adolescent means a person who has completed the age of 15 but not completed the age of 18. When we are talking about the adult means who has completed the age of 18. When we are talking about under the act is appropriate government, that is in relation to any scheduled employment. There can be the state government, and the state government can be there, central government can be there. When we are talking about the definition of the child means who has not completed the age of 14 years. Employer, recruited directly or indirectly, includes, if it is a case of the Factory Act in 1948, manager, or if it is a case of any of the government department, the head of the department, or the person appointed for the supervision and the control of the employees by the that department or the government. The chief executive officer for the of the local authority. Now, the scheduled employment, which has been defined in the section 2G of this act, it means an employment specified into the schedule or any process or branch of work forming part of such a employment. So, when we are talking about scheduled employment, because that has been given into the schedule, so we are going to take it. But for the scheduled employment, that is this kind of the employment includes any kind of the processes or the branches of the work. So, if into the one of the industry, one is doing the manufacturing work, so but the other is doing the packing, or other is putting the label on that, that product, they are making the item ready for the market, or so this is any kind of the process would be coming into the scheduled employment. So, might be the name of the employment is not given, or the branch of the work, so forming part of such a employment. So, this is a broad thing has been given. So, we can't say the processes or the branch of work will not be the part of the employment. They are absolutely, they would be coming under the purview of the scheduled employment if they are related with that particular employment. So, when we are talking about scheduled employment, that has been given in section 2G and in section 27. So, when we are talking about section 2G, it is divided into two parts. So, first part is number of the employment has been given, and into part 2 we are having, that is other than these employments. Say for example, if someone is doing the agriculture work, lively stocks or bees, or the kind of husbandry, other kind of the work which are not related with these employments. So, they have been given into, or any kind of the agriculture activity, farming, cultivation, they have been given into the second part. But into the first part we are having the number of the employments, and we have added section 27. So, 27 means, see, sometime if the employment has not been added into this act, and later on the government thinks so, the chances of because this employment is of such a nature, otherwise if we are not going to not going to add into the scheduled employment, the chances of exploitation would be too high. So, just to give the protection to those workers, they can, through their notification, the government can notify, and they would be giving the 2 months notice in advance. We are going to add this employment into the scheduled employment, they can do so. So, when we see, because if we see the domestic workers, they are not the part of it when we are talking about the scheduled employment, but so many states, they have included the domestic workers into the category of their scheduled employments. So, because when we are talking about say Andhra Pradesh, Karnataka, Kerala, Rajasthan and many more states, minimum 6 states, they have added the domestic workers into their scheduled employments. Everyone knows that because the labor law comes under the concurrent list. So, appropriate government, they can frame, they can if they feel so, they can add these, they can frame their own laws for their respective states. So, I am taking now scheduled employment category 1, that is a part 1. So, employment in any woolen carpet making or shawl weaving establishments. If someone is doing any work in any of the woolen carpet making or any kind of the shawl weaving establishments would be coming under the scheduled employment. Employment in any rice mill, flour mill, dal mill, employment in any tobacco including the bidi making manufacturing, employment in any plantation, that is to say any estate which is maintained for the purpose of growing singona, rubber, tea or coffee, employment in any oil mill, employment under any local authority, employment on the construction or maintenance of roads or in building operations, employment in stone breaking or stone crushing, employment in any lac manufacturing, mica works, employment in public motor transport, in tanneries and leather manufacturing, gypsum mines, barite mines, bauxite mines, manganese mines, employment in the maintenance of the buildings and the employment into the construction and the maintenance of runways, employment in China clay mines, kyanite mines, copper mines, employment in any clay mines. Because they have been covered, so many, kind of the mines has been covered with their respective acts, like employment in clay mines covered under the Mines Act, employment in magnesite mines covered under the Mines Act, employment in white clay mines, employment in stone mines, employment in silitile mines, employment in asbestos or fire clay mines. So these are the numbers has been given in part 1. When we are so the coverage has been given to all the workers, those who are doing in part 1 under the minimum wages. So this is a duty of the government, they would be giving the minimum wages to those persons which are into the scheduled employment. So all the scheduled employment, the part 1 would be protected. When we are talking about the part 2, that is employment in agriculture, that is to say in any form of farming, including the cultivation and the tillage of the soil, dairy farming, the production, cultivation, growing and harvesting of any agricultural or horticulture commodity, the raising of livestock, bees or poultry, or in any practice performed by a farmer or on a farm as incidental to or in conjunction with farm operations, including any forestry or timbering operations, and the preparation for the market and delivering to storage or the market or to carriage transportation to the market of the farm produce. If they are making already the item for the sale into the market, those if the person they are busy into doing the work into that process or into those branches, they would be covered under in part 2 of the scheduled employment. Now we are going to take an important definition of the wages, because when we are talking about the wages, wages means has been defined in section 2H. All remuneration includes house rent allowance, but not include the value of house accommodation, supply of light, water or medical attendant. Other amenities, services excluded by the order of the appropriate government, provident fund and employee state insurance contributions, travelling allowances or travelling concessions, some paid to defray special expenses due to nature of his employment, gratuity payable on discharge. Because when we talk about the definition, because into every act we are having the different definition has been given. So when we talk about the definition of the wages, here under the minimum wage act, it is not the same definition which has been given under the different act. So this is the main problem with the with the labor law, and for this, that's why we have government, they have amalgamated and they have subsumed so many legislations, and they now all the legislations these and they have been now this minimum wages act is a part of the code on wages now. So when we talk about the definition is, we are talking about into the wages all the remunerations would be including, and it includes your house rent allowances, HRA is a part of it. But if the employer is giving any house accommodation, or sometimes the employer give the house accommodation to the employee for the stay, that is not the part of the wages. And supply of the light or the water or medical attendant, they are not considered to be the part of the wages, or any kind of the services or the amenity, but which has been excluded by the appropriate government is saying it will not consider to be the part of the wages, it will not be the part. PF will not be the part of the wages, ESI contributions they will not be, because these kind of things, PF and the gratuity, they would be given when the person retire or the person is going to be discharged. If it is a case of the travelling TA, travelling allowances or travelling concession, it will not be considered to be the wages. Sometime if the expenses has been spent on someone just to because of the special reason, so this kind of the expenses which has been incurred by the employee will not be considered due to the nature of the employment. He has to spend that he had to go for this special expenses, so that will not be coming under the definition of the wages. Now the next definition is employee. Employee means skilled or unskilled, manual or clerical. This is a wide definition. Here we are including the out workers, is also outsource worker is included into the definition of the employee. So we would be talking about other cases. Into A.V. Prakash versus Senior Labour Inspector, definition of the labor is very restrictive, but the definition of the employees has been covered in the wider ambit. When we are talking about a case that is a Bandhwa Mukti Morcha versus Union of India, it's a very important case. Here the Supreme Court has decided in 1994 that piece rated workers are also entitled to the minimum wages, because sometime why we are talking about the piece rate workers, because the wages, the work can be given, we will talk about later. So work can be given on a daily wages, it can be on a piece rate wages, it can be on a overtime rate of the wages, or it can be a guaranteed time rate of the wages. So we are having this kind of things. So when we are, if the someone is not able through the, if the someone is doing the work on a piece rate wages, and whole day the person is not able to earn the minimum wages, so the minimum wages has to be given to that worker, because the person has spent that minimum hour, because so that's why the Supreme Court has held that if the someone is doing the work on a piece rate of the wages, that is would be entitled to get the minimum wages. In case of the Patel Ishwar Bhai Pramod Bhai versus Taluka Development Officer, into which tubal operators working under the local authority in scheduled employments are entitled for the minimum wages. Already we have mentioned that the tubal operators would be coming under this category, because we are considering the those employments which comes under the local authority, where the local authority is the appropriate government and assign the work to someone. So those would be getting, those workers would be entitled to get the minimum wages. BD Udhog Sangh versus State of Madhya Pradesh. So if the payment is in nature of the lay of compensation, is not wages, it means, because normally when we talk about, so lay of compensation can be given, but it is not the wages, because the layoff is, this is not the fault of any of the worker or the employee, because due to the the material was not there into the industry, that's why the employer has told it to the employee, because of the shortage of the material, shortage of this thing, or because of this problem, we cannot engage you right now, we would be calling you once the things would be ready. So this person is, this worker is entitled for the lay of compensation, but that's why the lay of compensation would not be coming under the category of the wages. Athene municipality case, discharge employee is also the definition of the employee under the definition, if any of the employee has been discharged, would be coming under the definition of the employee. As we discussed, the definition of the employee is that is in a wide ambit. In section 3, fixation of minimum rate of the wages. So appropriate government shall fix the minimum rate of the wages payable to the employees in any scheduled employment for the part 1 and part 2 of this scheduled employment, and in case of the employment covered in part 1, the minimum rate of the wages must be fixed for the entire state and no parts of the state being omitted, because this is possible. That is, if the scheduled employment is coming into the part 1, like when we were talking about the scheduled employment, the carpet making or the shawl weaving and many more. So for this kind of the employment, the appropriate government, they can fix the minimum wages for the whole state. And in case of the employment specified in part 2, the minimum rates of the wages may not be fixed for the entire state, parts of the state may be left altogether due to the regions or due to the, because we are not having, due to the diversity, this is not possible to fix the wages for this. For the agriculture, we cannot give that, for the cultivation, we cannot give the uniform rate of the wages, and many more things we had there, say poultry farm and other things. So uniform rate of the wages is not possible to set for the part 2 of the scheduled employment. If there are less than 1000 employees in the whole state in any scheduled employment, the appropriate government may not fix the minimum rate of the wages for the scheduled employment. But when the number increases 1000 or more, appropriate government can fix the minimum rate of the wages. So the principle is, this is the duty of the appropriate government, is they can fix the minimum wages, but with this condition the threshold has to be 1000. If the number is less, the appropriate government is cannot fix the minimum wages. But if after making the inquiry and after some time, if the government feels so, now they have reached to this number, then they can fix the minimum wages for those employments if they have reached to the 1000 in number. The rates to be fixed need to be uniform. Different rates can be fixed for the different zones or for the different localities. And when we talk about Bijoy Cotton Mills versus State of Ajmer, the constitution validity of this has been challenged. Already we have discussed this case, because when the employer, they were saying this is that is a violation of our right to carry on trade or the profession. So we have taken up already. Revision of the minimum wages. So appropriate government may review the minimum rate of the wages at intervals not exceeding 5 years. This means that the minimum wages can be revised earlier than the 5 years, but the gap between the two revisions should not to be more than 5 years. So this is expected from the government, that is because once they would be fixing their wages, this is duty of the government, appropriate government, they would be making the revision of the minimum wages. So that is after the 5 years they would be revising the wages. Manner of fixation, revision of the minimum wages in section 3 clause 2. So appropriate government may fix the minimum rate of the wages, that is minimum time rate, minimum piece rate, guaranteed time rate for those employed in a piece work or overtime rate. So the appropriate government may fix the minimum rate of the wages, minimum time rate. It means we are talking about number of hours. If the time has been fixed, that is for the 8 hours, they would be getting their minimum wages. And if we are talking about minimum piece rate, if the work has been given on a piece rate wages, so if the employer has assigned the work, they can do this work into that establishment, into that factory, or sometime they can do this kind of the work, they can carry this work into their homes or any dedicated area for this. So if the piece rate work has been done, so they would be entitled to get the wages once they would be completing their piece. If the thing has been set, like for the one piece the 10 rupees would be given, for the 10 pieces the 100 would be given, that is the piece rate wages, they can do in that way. So guaranteed time rate for those employed in a piece rate wages, because sometimes someone is doing on a piece rate wages, but they could not complete the 100 pieces on that day. So does it mean they will not be entitled to get the wages? Because that is the appropriate government, they can give the guaranteed time rate because they have spent this much of time. So in that case the government can give them the minimum wages. In spite of it, they could not complete their number of the pieces on that day. So overtime rate of the wages, because when we are talking about overtime rate of the wages means that is if someone is doing the work into the industry, the time has been fixed to 8 hours, but additional 2 hours the person was there into the industry and was doing the work. So whether this person would be entitled to get the overtime rate of the wages for this next 2 hours? Yes. Then in that case, because the wages can be given according to this proportion. But if sometimes the employer thinks so, like I can complete this my work if I would be giving this work on an overtime rate of the wages. So they can go for this kind of the practice, but it cannot go beyond the 10 days. After that, section 3 clause 3, it talks about different minimum rate of the wages may be fixed. So different for the different schedule employments, different classes of the work for the same schedule employments. So they would be having the different wages for the different schedule employments, different classes of the work, even for the same schedule employments. Adolescents, adults, children and the apprenticeships, they can have the different wages and different wages on the basis of the localities. Further, minimum rate of the wages may be fixed by one or more of the following wage periods, namely by the hour, day, month, or by such other wage period which may be prescribed. So, either someone is doing the work on the basis of the hour, say for example 4 hours, they would be getting the wages accordingly. By the day, 1 day, 2 day, 3 days. By the month, 1 month, 2 months, or by other large period as may be prescribed. Where such wages, such rates are fixed by the day or by the month, the manner of calculating wages for the month or for a day as may be case may be, that can be indicated. Section 4 talks about minimum rate of wages. Any minimum rate of the wages may consist of basic rate of wages plus cost of living allowance, or basic rate of the wages plus cost of living allowance plus cash value of the concession for supplies of the essential commodities at the concession rates, or all inclusive rates allowing for the basic rate, the cost of living allowance and the cash value of the concession. Because when we are talking about the minimum rate of the wages, they may consist of that is a basic rate of the wages, because when someone is coming into the industry, at the very beginning, at the initial level, the basic rate of the wages can be fixed, into which they can add the cost of living index. So, when we are talking about it, means we are talking about the DA, dearness allowance, or the cost of living index, they can do in that way, or basic rate of the wages, that is plus cost of living index they can add, plus cash value of the concession for supplies of the essential commodities at the concession rates. So, sometime if they are giving the concession commodities which is on a concession rates, so instead of giving the essential commodities, they can give the cash value for those concessional commodities, and they are at a concession rates. All inclusive rates allowing the basic rate, the cost of living allowances and the cash value of the concession. The cost of living allowance and the cash value of the concession in respect of the supplies of the essential commodities at the concession rates shall be computed by the competent authority at specified intervals in accordance with the directions specified by the appropriate government. Because when we are talking about concession rates of the essential commodities, so we are having, there is the policy of the government, and accordingly they decide and they can add into their the minimum wages. What is the procedure for fixing and the revising minimum wages? The appropriate government can follow either two methods we are having, that is the committee method and the notification method. When we are talking about committee method, so appropriate government, they can appoint the committee who would be making the inquiry and advice in respect of the fixation or the revision of the minimum wages. And after considering the advice of the committee, the appropriate government may fix or revise the minimum rate of the wages by later on by the notification into the official gazette, because that is a committee method, they are giving the advice, but it is not necessary the government would be making the compliance of the advice which has been given by the committee. Notification method, so through this method appropriate government would be notifying into their official gazette, and they would be publishing its proposal for the information of the persons likely to be affected, and 2 months notice period would be given for making any kind of the representation who are the interested parties. And after considering all the representations and making the consultation with the advisory board, so the appropriate government would be fixing or revising the minimum rate of the wages by their notification into the official gazette. So they can notify and they would be involving the public, and so through this matter they can notify any of this kind of thing. And the minimum wage rates shall come into force from the date specified into the notification. If no date is specified, wage rates shall come into the force on the expiry of the 3 months from the date of the issue of the notification. When we are talking about the case of Edward Mills Company Limited versus State of Ajmer, committee appointed under section 5 is only the advisory, and the government is not bound to accept the recommendation of the committee. In section 7, constitution of the advisory board is constituted by the appropriate government for the coordinating the work of the committee appointed, which are appointed in section 5, and advising the appropriate government for fixing and revising the minimum rate of the wages. Section 9 is talking about the composition of the advisory board. So here that is the advisory board would be consisting of the persons who are nominated by the appropriate government, and they are representing the employer and the employee and the independent person. But the equal number of the representation has to be there. 1/3 the representation would be coming from these three from the government and from the employer side. So, and one of the independent person shall be appointed as the chairman by the appropriate government. The same is the case of the constitution of the Central Advisory Board in section 8. So, central government shall appoint a Central Advisory Board for the purpose of advising the central and the state governments in the matter of fixation and the revision of the minimum rate of the wages and the other matters, or for coordinating the work of the advisory board. When we are talking about the composition of the Central Advisory Board, so they are also having the similar kind of the procedure. So there they would be taking the members, that is a 1/3 of the they would be taking the members from the employer side and from the employee side, and there would be the equal number of the numbers, and the independent person would be taken that should not exceed the 1/3 as we discussed earlier. Now, section 11 is talking about wages in kinds. So, minimum wages shall be paid in cash, and it can also be paid in kind. If there is any custom and approved by the appropriate government, supply of essential commodities at the concession rates can also be authorized, because when we are talking about the wages, now this kind of the thing has been changed now we are not having any system of the kind payment or the capping is there, but under this act has been came to the implementation in 1948, and at that time the workers, they hadn't any account, or we hadn't the effective digital transactions. So at the time the procedure was the payment could be given in cash, or the payment could be made in kind. So when we were talking about the payment can be made in kind, means instead of giving that is the full wages to the workers, and sometime the employer they used to give the kind of wheat, rice, or the other essential commodities. So that is, but for this they have to take the of course they have to take the permission from the appropriate government, and they must have to be regulated by some policy of the appropriate government. Payment of the minimum rate of the wages. It is noted that the minimum wages must be paid irrespective of the extent of the profits, the financial condition of the establishments. The employer shall pay to every employee engaged into the scheduled employment wages, which shall not be less than the minimum wages fixed by the appropriate government. Payment of less than the minimum wages notified by the appropriate government is an offence, because already we have taken this point, that would be considered to be the offence, and it would be considered to be the big R, and the person can be penalized for this in Article 23 of the Constitution of India. Section 13 is talking about fixing hours for the normal working day, because that is number of hours can be that has to be notified by the government, and that is how many hours, 8 hours. So either it is 10 to 5, 9 to 5, or either it is from 10 to 6. So number of hours has to be decided. Day of rest, appropriate government has to decide which day would be the day of rest, whether the Saturday would be the day of rest, or Sunday, or any other day in a week, or if working on any day of the rest, so overtime rate of the wages has to be given, and subject to the condition by the government. So if it is a case of the irregular work, because if it is not an irregular kind of the work, or sometimes the casual kind of the work, or the complementary nature of the work is there, so then in that case it is not necessary they would be getting their wages once the work would be completed. Section 14 is talking about overtime. Extra rate of the wages would be given if someone has given the overtime, but this limitation we are having, that is cannot call the workers more than the 10 continuous day. Wages of the workers. who work for less than the normal working day. Say if someone has done the work, any of the worker has done the work which is lesser than the normal working day, then in that case whether the person would be entitled to the wages. Yes, because sometimes the productivity cannot be to that extent and the person is entitled if the someone has done the lesser than the normal working day. It is not necessary all the time the person would be doing the work into the industry. So, section 16 is talking about wages for 2 or more classes of the work. Where an employee does 2 or more classes of the work, to each of which a different minimum rate of the wages is applicable. Say they are having the different minimum wages, then the employer shall pay to such an employee in respect of the time respectively occupied in each such a class of the wages and wages at not less than the minimum rate in force in respect of such a classes. So, they would be getting the different minimum wage into their different employment. Minimum time rate wages for piece work, where an employee is employed on a piece work for which the minimum time rate and not a minimum piece rate has been fixed under this act. The employer shall pay to such employee wages at not less than the minimum time rate, because the person has been fixed for the minimum time rate. And maintenance of the register and the records in section 18, it is a procedural section and it is the responsibility of the employers. So, this is the duty of the employer. They must have to maintain the register and into which he has to make the entry. He must have to enter all the particulars, say name of the employees, what kind of the work they are doing, wages being paid to those employees, and they would be making the exhibition of it. They must have to exhibit this kind of the information. Section 19 is talking about the inspector, and the inspector would be would be appointed by the appropriate government, and he is the public servant which has been defined in Indian Penal Code, and the inspector can visit at any hour into the any industry and he can examine the persons, he can examine any of the employee, and inspector can seize the record. If feels so he can seize the record of the Section 20 is talking about the claims. This is very important because the claim here we will talk about what kind of the matter would be coming under the definition of the claim. The appropriate government may by notification in official gazette appoint an authority to hear and decide for any specified area all the claims. So, the claims can be, Section 20 is talking about claims. The appropriate government may by notification in an official gazette appoint an authority to hear and decide for any specified area who would be deciding the claims arising out of the payment of less than the minimum rate of the wages for work done on the day of rest in respect of the wages at the overtime rate to the employees employed or paid in that area. So, the kind of the matter would be taken by the appropriate authority here. Say either someone has done the work on a day of the rest, or either someone has done on an overtime rate of the wages, or to whom the arising out of the payment who has given the lesser than the minimum wages. So, this matter would be deciding by the authority. Authority to be appointed: any commissioner for the Workmen Compensation Act 1923, any officer of the central government exercising functions as a labor commissioner for any region, any officer of the state government not below the rank of the labor commissioner, or any other officer with the experience as a judge of a civil court or as a stipendary magistrate. We are not using this term here in India because normally it was we have taken this term from the UK. And who may apply? Where an employee has any claim, any of the following may apply to the authority for hearing and deciding the claim: the employee himself, or any legal practitioner, any official of a registered trade union authorized in writing to do that act on that behalf, any inspector, or any person acting with the permission of the authority. Every such application under section 20 shall be presented within 6 months from the date of which the minimum wages and other amount become payable. The time period is 6 months. This is they would be giving the application within that stipulated time, and when the applicant satisfy the authority that he had a sufficient reason for not making the application within such period, This is a duty of the person is onus of proofs will depend upon the person. Amount of the compensation when an application is entertained by the authority shall hear and decide, and accordingly they can give the directions. So, and sometime a single application in respect of the number of the employee, that would be adequate. When we are talking about the penalties for the certain offences, that can extend up to the 6 months or a fine for the 500 rupees. If the employer is pay to any employee less than the minimum rate of the wages fixed for the employee or class of work, or less than the amount, that is, then in that case the fine can be that can be 6 months or fine up to the 500 rupees, or contravenes any rule which has been mentioned in section 13, again shall be punishable, and the fine can be imposed 500 rupees. And where any employer who contravenes any of the provision of this act or the rule which has been made, or if any penalty has been provided for the contravention, would be punishable with a fine which can extend to the 500 rupees. In imposing of such a fine, the court shall take into the consideration the amount of any compensation already awarded against the accused. In that case, any employer who contravenes any provision of this act or any rule made under this act shall, if no other penalty is provided for such a contravention by this act, be punishable with a fine which can extend up to the 500 rupees. When we are talking about the cognizance of the offences, no court shall take the cognizance of a complaint against any person for an offence involving the payment of the less than the minimum wages, unless the application in respect of the fact constituted such offence has been duly presented under section 20. I mean, this application has been given before the authority and granted the appropriate government or the officer to take up the matter, or the person is making the contravention given under section 13, then in that case, so offences by the company, because the company is considered to be the artificial person but would be liable, and but this is the duty of the company, they must have to prove it without the knowledge or the due diligence, because they have taken a due diligence and they were not aware about it, where the minimum wages has not been given. Now, the section 24 is talking about the bar of suit. Bar of suit is talking about if any matter is already pending before the authority or the decision has been taken, then in that case, sometimes the decision has been given into the favor of the plaintiff, then there is a bar of the suit. Contracting out, if any kind of the contract or agreement has been drafted in such a way the employer is making the exemption, he will not be accountable for not paying the minimum wages, or the employee himself is ready to waive the right or relinquishes the right. So, this kind of the agreement or the contract will not exempt the employer from the liability. So, this kind of the things cannot be drafted. Exemption in section 26, power of the state government to add any of the schedule already we have discussed, where the appropriate government thinks so. This kind of the employment has to be added, so they can do so, they can add it through the notifications, and power of the central government to make the rules. So, if the appropriate government is the central government and they want to add something and they want to make the more rules for the better functioning of the minimum wages, they can frame the rules for this. Further, the rules can be framed. So, this is from my side. Thank you so much.
Hello and welcome to this piece of literary snippet. Perhaps the most popular literary genre after novel is the short story. Sharp, compact narratives whose charm lies not only in what is said, but also in what remains unsaid. Today I will be reading one of the shortest instances of a short story that I have ever encountered, And indeed, the very charm of this particular story that I am going to read out today lies in the way it abruptly ends. It is an ancient tale from Mesopotamia, which has been retold by several authors, among whom the name of Somerset Maugham stands out. The adaptation that I'll be reading out is perhaps the closest to the one that Maugham wrote. The story is titled, in all of its adaptations almost, as Appointment in Samarra. Here is the story. A merchant in Baghdad once sent one of his servants to the market. The servant was supposed to buy provisions for the merchant, but when he returned, he came back empty-handed. Indeed, the servant had all gone white, and trembling with fear, he told his master that he had met death in the marketplace. When I entered the market, the servant said to his master, I was jostled by a woman, and when I turned to look at her, I saw that she was death. I am very scared, master, because death looked at me with a threatening gesture. Can you please lend me your horse so that I can fly away from Baghdad to the town of Samarra and thereby escape death? The master, being a good man, gave his servant his best horse and saw him gallop off to Samarra to escape death.